Right, good afternoon, everyone. Speakers on my panel, colleagues in industry, practice, and academia. My name is Iris Chu, and I'm hosting this afternoon's panel on the future of the annual general meeting. I'm a professor of corporate law at UCL and director of the Center for Ethics and Law, which has generously sponsored this webinar. The COVID-19 pandemic has caused some severe disruption to many economic relations. And although virtualization can bring about some continuity in workplaces, at conferences or seminars like these, we can't say that everything is back to normal or proceeds as usual. This institution of the annual general meeting is a legally enshrined procedure. And it's also an institution that caters for shareholders' rights, protections, and corporate accountability to shareholders. How has virtualization changed this? And are there more radical effects upon corporate accountability? We have assembled a panel of 6 esteemed guests today to give their views. So the order of the proceedings will run as follows. We have fielded 6 questions for each of our 6 panelists, and each one will speak for about 10 minutes. And then I will invite the rest of the panel to comment. Following that, the audience is invited to submit questions through the Q&A function, and I'll select a couple for the speaker in question, after which the next panelist will take the floor. We will appreciate that you can send your questions in advance before the speaker concludes his or her presentation, so that we'll be able to have some time to curate the questions for the speaker in question. Let me first introduce briefly our first panelist, Vanessa Knapp, OBE. Vanessa is formerly partner at Freshfields and is now visiting professor at UCL and at Queen Mary. We are delighted to have Vanessa with us today. And Vanessa is addressing the question on the fitness of the Companies Act for general meetings and corporate accountability more broadly in today's age, as well as in this COVID-19 pandemic era. So let me now give the floor to Vanessa.
Thank you, Iris, and good afternoon, ladies and gentlemen. It's very nice to be here virtually. It would be even nicer to be there in person, but this is a good second best. I wanted to start off by thinking about what the Companies Act says at the moment. And particularly for virtual meetings, there's not a great deal in the Act. So we've got the Section 360A in the Act, which we introduced to implement our obligations under the Shareholder Rights Directive in 2007. And all that says is that nothing in the part of the Act that deals with meetings is to be taken to preclude holding and conducting meetings in a way that people who aren't together present at the same place can by electronic means attend and speak and vote. And then there are some requirements for traded companies to make sure that the requirements and restrictions that they want to impose on their members are only those which are necessary to make sure that they can identify the people involved and make sure that the electronic communications they're using are secure, and they have to be proportionate to what they're trying to achieve. And it also says that companies can still ask for reasonable evidence that people are entitled to participate in the meeting. So not very much there. And I think that comes from the Shareholder Rights Directive, which was phrased in an interesting way, because that says it's the member state that has to allow the company to offer the shareholders any form of participation in a general meeting by electronic means. So it's not a right given to the shareholders, it's an obligation on the member state to let companies use e-participation if they want to. And the other thing that I think is relevant is just to remember that we of course have the law in the Companies Act relating to general meetings that predated all of the shareholder rights stuff. And in particular, the section I'd pick out as causing problems for people is section 311, which says that any notice of a general meeting has to say the time and date of the meeting and also the place of the meeting. And certainly I know amongst practitioners, there's a variety of views as to what the place of a meeting means and whether place means a physical place or whether it can just be a link to a virtual space or not. Now, if you can cast your minds back to before COVID, which does seem a long time ago, I think even before then, people were asking questions about whether meetings of shareholders in a physical way in one place was still a meaningful activity or not. And that goes back, actually, I can remember when the company law review predating the current Companies Act was going on, people asking whether it really did make sense to have physical gatherings of shareholders. And I think also part of this is driven by the fact that very often institutional shareholders, when they're not happy with something that the directors are doing, would tend to try and resolve the problem by engaging before a meeting behind closed doors. And so it isn't always obvious to other shareholders or to the public what's going on. But you can still see when an issue becomes hotly contested, that physical gatherings of shareholders are still very important. So there are examples, both of cases where a company will withdraw a resolution that they had put forward, or they will accept a new proposal that's been put forward, or there'll be a very heated meeting about a particular topic. It might be a takeover, it might be remuneration. And so there are good examples, I think, that things still do happen at physical gatherings of shareholders. The move towards a virtual meeting, I think, really got going in about 2017. I think it was Jimmy Choo that was the first UK company to try and have a virtual meeting. And the Investment Association was quite swift to make a public statement about that. And they said very clearly that virtual meetings, where they're virtual only meetings, aren't in the best interests of all the shareholders. And companies shouldn't be using them. And they felt that it was detrimental to board accountability. And they also said that if companies were putting forward changes to their articles to allow them to have virtual only meetings, they were unlikely to support those changes. And that they saw physical meetings of shareholders as an invaluable opportunity to raise particular concerns with the board in a public forum. And they wanted to have that in their armory of weapons as part of their stewardship activities. Not replacing all the other things that they might do, but it was an important part of what they had available to them. And that it was part of their escalation approach to make concerns public at an AGM, presumably in cases where they hadn't been able to make progress. But they did accept that using technology in conjunction with a physical meeting could be beneficial. I think their worry was that virtual meetings, virtual only meetings, somehow removed accountability from the board to the shareholders. And they also said they thought it was harder to identify who were the other participants in the meeting and what their views were. And it was also harder to work out whether people were agreeing or disagreeing on something. And their worry was that the companies might be attempting either to filter the questions or to control which shareholders got to participate. And they didn't like that. And really, after the Investment Association came out, and then they were joined by ISS, the US proxy advisor, who also said they were going to vote against companies doing virtual only meetings. It became pretty clear to companies that they couldn't go down that route until we got to the pandemic, where obviously people had to rethink what they were doing, how they were doing it, because it just was thought not to be safe to have large congregations physically in person. And so ISS changed its guidance. And also the guidance that the FRC and BEIS put out on meetings was very helpful, partly because, as well as giving guidance to how to hold virtual only meetings, one of the things they did was to stress that giving all the shareholders the opportunity to ask questions and get answers before they had to vote, and the importance of making the answers available to everyone at the meeting and in written form after the meeting. Or if you were doing a virtual meeting and you could do it actually in real time, that was good as well. So I think if you think about where have the problem areas been identified to be? I would say that the areas of concern seem to be, firstly, who gets to ask questions and how do they do that? A worry about whether the company is filtering the questions that get answered. And do the various shareholders have the ability to gauge what the views of the other people in the meeting is? So going back to Iris's question about, well, do the Companies Act provisions, do they still work for all of this? I certainly think it would be helpful to deal with this problem about whether place really means a physical place or could be a virtual only place. That would be good news. Another thing I think that might be helpful to look at is section 319A, which applies to traded companies. That says that the company has to cause to be answered any question that relates to the business that's being dealt with at the meeting, that's put by somebody attending the meeting. But then there's a carve out, which I remember at the time was quite hotly contested when the Shareholders' Rights Directive was being implemented. It says that the company doesn't have to give an answer if it would unduly interfere with preparations for the meeting or involve disclosing confidential information, or the company is given an answer on a website, or it's undesirable in the company's interests or for the good order of the meeting. Now, I think one of the problem areas is the role of the chair in all of this, because the role of the chair is still governed by the common law and also by what it says in the company's articles of association. And maybe partly because it's not in writing, can we be sure that all chairs are actually as good at what the company law on the role of chairs at meetings is as they should be? Obviously, the chair is there to ascertain the sense of the meeting, to regulate the proceedings, to act in good faith, to follow whatever it says in the Articles of Association and make sure that the meeting is conducted in a fair way, but also effectively and efficiently. And normally articles will give you some sort of what I would call more procedural type provisions about the role of the chair, but they don't major so much on what the chair is there to do. So I thought I'd finish just by offering some thoughts as to what would be a good way forward in trying to make things better, because I believe we should be able to come up with a solution that will allow virtual only meetings which people can really trust in. I don't think hardwiring requirements into the Companies Act is really going to work, because I think that element of discretion that the chair has is very important. It's the balance between making sure people do get to ask questions and answers are given. But what I think is that if we could get some good practice suggestions that are supported by the companies, the shareholders, proxy advisors and practitioners as being good workable solutions as to what are the sorts of procedural things that companies could do in the way that they deal with questions they receive, making it transparent as to what the questions are, how they're going to deal with the questions. If we could get some good practice around that, that would be excellent, I think.
Right, thank you very much, Vanessa. Shall I now turn to the rest of the panel for any comments that you might have on what Vanessa said about the Companies Act? Any views at all from the panelists?
I was just going to say, I think she did a brilliant job in setting the scene. And I'm not sure I have a question, but I think she's leading into her comments, as did yours, Iris, set a good foundation.
Right, thank you, George.
Could I ask a question? Vanessa,
right.
Your point about using AGMs so that shareholders can actually take the temperature of other shareholders' views. Do you think that nowadays that is a meaningful need? Given that shareholders, have the ability to find out what other shareholders are thinking in a variety of other ways?
Well, I think if you're a large and influential shareholder, that's probably true, because you're probably a member of the investor forum and you can agree with other large shareholders that you have a particular issue about a particular company and you want to go and talk to the chair. But I think if you're one of the smaller shareholders, whether you're institutional or whether you're an individual shareholder, it's much harder for you to do that. And I don't know, maybe you know better than I do, Roger, what somebody in that sort of situation, how they would go about finding out about what the other shareholders think.
I think Deirdre has a question as well, or a comment.
Yes, I found that very interesting, Vanessa, and I'll be returning to some of the same territory when I come to look at the EU provisions that you mentioned from the Shareholders' Rights Directive. I thought it might be also interesting to mention the more Luddite approach that some companies adopted, at least in Ireland, which was to hold closed AGMs, but where they're just behind closed doors. And we saw, for example, Grafton PLC, one of the shareholders actually took court proceedings seeking an injunction saying it was unfair. We had other companies who did a kind of a lottery approach and said a certain number of people could attend. And that equally obviously was problematic, but they didn't feel set up to opt for technology, and they decided instead to just shut the thing down, which is probably the worst you can do. About us having maybe reservations about not being able to eyeball directors in an online context. Obviously, I would have significant concerns about deciding, well, let's not try at all, which partly was because the AGM season was on, but that was something we saw. I probably was not maybe seen in the UK, but certainly we saw that in Ireland.
I think the UK also had problems because of the short amount of time that the companies had to prepare for this. I think, normally most companies are preparing for their AGM almost as soon as they finish the last one. And suddenly to have large numbers of companies trying to move over to some sort of online meeting, either for everything or, together with some sort of physical meeting, is tremendously difficult for everybody if you're doing that at short notice. So one of the things I hope is that if we're thinking sort of what we might do in the future, we can do a better job of trying to get organized and let people set in advance. And I certainly don't think, drawing lots for who can go to a meeting is a very good way of going about it.
Thank you.
Right, thank you, Vanessa. I have a question from the audience asking about vote by the show of hands. Basically, I think what our member of the audience, Mr. Toby Tan, is interested in finding out is whether voting by the show of hands is somehow compromised by the virtualization of the AGM.
It's the thought that because you can't see whether other shareholders are putting their hands up or not, then you don't have some of the information available to you that you would have otherwise. I must say, I have always thought the vote on a show of hands was quite a strange idea anyway, because there's such an enormous disparity in the numbers of shares that individual shareholders have. So I'm more of a fan of voting on a poll than on a show of hands. I mean, I can see the convenience from the company's point of view of having a vote on a show of hands if you think something is not contentious as a way of doing it. But I sort of, in the scheme of things, I don't think that would be top of my list of things to worry about.
I mean, I wonder if people would agree that at sort of large companies, voting by show of hands seems a rather anachronistic way of voting. I mean, I can understand it for very small companies, with very simple shareholder structures, but in large companies, seems a strange way of continuing.
Can I just add that? Oh, sorry.
I was just saying it's one of the few areas where I think Britain, which is such a leader in many aspects of corporate governance, seems to be lagging behind other parts of the world.
Right, and on the show of hands, Hans Kristoff actually has a comment for Vanessa, so can I please invite him to come in? I think that is one of the problems of the virtualization of a seminar.
I used electronic too, but just a quick comment, and thank you for your comments. I think it's really important that we are a very international panel, and the audience also very international, that we think beyond the UK. And the AGM tradition in some markets in continental Europe, but also in Asia, is a very different one. And I think the role of AGMs in a country like Germany is a very different role from the role of AGMs in Great Britain. And I think this goes hand in hand with the differences in stewardship tradition. So when I started as a young man doing engagement with German companies, there was no board level dialogue between investors and companies. So sometimes AGM was the only way to make your points. I also think what you said about share discretion is really important, because in Germany, the company needs to answer every single question that is put on the table. So you had even the virtual AGMs lasted up to 8 or 9 hours with Deutsche Bank, for example, this year, because there's a legal requirement. Whereas here, the chair can just say, I've had enough, let's move on to tea and coffee. And I think the variation I have seen in my life, it was Korean AGM, 30 minutes, all done to up to 11, 12 hours until midnight in Germany. I think I think we need to keep that into consideration also when we talk about the role of AGMs going forward in different markets.
Right. Does Vanessa have anything to add to that, or shall I move on?
No, why don't you move on?
Right. Okay. All right. Shall we invite our second panelist, George Dallas? George is Policy Director for the International Corporate Governance Network. George's full bio is on our event registration page, as is the case with all of our speakers. And so my introduction is very brief in the interest of time. George is addressing the question as to what shareholders' main concerns are with the virtualization of AGMs. Right, over to you, George.
Thank you, Iris. Let me put you all on share screen really quickly. Thank you again. A very opportune time to have a conference on this topic, and it's an important one. So thank you for organizing it. For those of you who don't recognize and may not know who ICGN is, it's the International Corporate Governance Network. It's a network. It's a membership body, but it's founded in 25 years ago. But I think the things, just to leave with you, sort of to Hans's point earlier, this is a global body. And we're investor-led, and our investor members represent 54 trillion in assets under management. So we're talking about a substantial part of the international institutional investment community as part of our membership base. And we exist basically to try to improve corporate governance in companies that we invest in on behalf of our members, but also try to be responsible citizens ourselves in terms of our own stewardship and responsible investment practices. Let me, having said all of that, what I'd like to do is just really talk about the issue that was put on the table in terms of how COVID has sort of prompted this discussion, or if nothing else, accelerated this discussion about the future of AGMs. And as Vanessa very capably outlined, virtual meetings became a necessity, sort of thrust upon us, not just in the UK, but globally. And this is in jurisdictions where they previously just haven't been allowed in a legal context, and this all had to change. And I think in that environment, which I think we're still in to some extent, I mean, it was and is a time for mutual support and compromise between companies, investors, and their stakeholders. And I think if you observe at least how the initial patterns of behavior, we'll see how they hold up. I think investors generally recognize that there is the need to compromise and to share the pain, not only with regard to how AGMs might change, but delayed filings or even reduced dividends, and perhaps recognizing that companies may have lower earnings to support their employment base. So this is a time of compromise. But I also think we need to look ahead and say, particularly in the AGM question, once it is over, what do we think it's going to look like? In ICGN, if you go to our website, you'll see that we recently published a viewpoint, a sort of a report on this issue, which outlines, I think, firstly, the importance of the AGM to investors. And I think both Iris and Vanessa basically articulated that very well. It's central to corporate governance, central to shareholder rights and stewardship. It is the opportunity for shareholders to hold directors to account and to exercise their ownership rights. So this is very important. At the same time, at least how it's become institutionalized, it's also very easy to criticize AGMs. They are in many ways flawed. And if nothing else, perhaps the COVID crisis is thrusting upon us, if against our will initially, an opportunity to rethink this and perhaps how technology might be in a position to help us go forward. But I think to do this, maybe just a quick whistle stop through the various pros and cons of AGMs and what the physical meeting and the possible alternatives. Physical meetings, I do believe that there's substance in what we call the, look them in the eye context. It provides for both formal and informal interaction for shareholders to communicate with each other as well as with the company. This is a huge event for retail shareholders. I think the point was rightly made that institutional investors often have other engagement opportunities. But it is very time consuming. As Hans pointed out, in some places, hugely time consuming and therefore costly, both to companies and investors. And for institutional investors, which don't only have hundreds, but thousands of companies in their portfolios, it's just simply impractical to become involved except in exceptional circumstances. So some real pros and cons. Virtual only, I could see why a company would like it to be the best of all worlds, probably the most cost effective. It does provide wider access to shareholders without the need for physical presence, which can be positive. But the questions that I think were outlined earlier, which I needn't belabor here, is that, the question is somehow this less of a meeting for that, or the process of virtualization, does this somehow dilute the impact or the input that investors might be made in terms of how questions could be filtered or possibly sanitized? And I think if nothing else, taking away the audio, taking away the visual effect makes it less immediate. So I think that's going to be, you're going to find, I think, investors not supporting that. Having said that, I think where I think technology is taking us and reality is taking us, and maybe in a way that we should embrace, is maybe the way forward is to look at hybrid, which combines the benefit of an immediate shareholder interaction for those who attend with the benefit of broader access to institutional shareholders. Now, if I was a company, I'd say this just makes my life more complicated, more costly, and I could see why that could be potentially resisted, particularly maybe for smaller companies where we do need to think about proportionality. And there's still the potential, if it's done poorly, to have the problems relating to sanitizing questions and filtering out the difficult questions from investors. So is hybrid the way forward? Yes, but, and I think the idea is let's embrace the technology, but let's establish some ground rules. And a viewpoint that we published recently sort of outlined, and again, you can read it at your length, but there's several important technical issues that we need to think about, including participant verification, the technical risks that come with both having a physical as well as an electronic presence. The cost factor, is this going to be more costly, and is that cost benefit analysis worth it? And then I think the issues that investors would still be concerned about are the ones in 4, 5, and 6, undue control of the meeting conduct and messaging, reduced opportunities for interaction between the company and the shareholders, and any sort of non-transparent or mediated approach is likely to introduce the quality of interaction and perhaps the credibility of the meeting. So these are the issues that I think we need to be concerned about. And then if we are talking about what should some of the, from an investor perspective, an aspirational investor perspective, what should some of the basic ground rules be in a hybrid virtual meeting to protect shareholder rights? Well, here's some of the ideas that my colleagues have put forward. Virtual meetings, they should also include physical meetings, but they should be in a video format. Audio only is inadequate. The same points discussed earlier, participants should be able to speak at the meeting, the open microphone concept to speak to the directors. All shareholder proposals should be voted on. Shareholder participants should be in a position to ask questions to the board. Questions asked to the board in advance of and during the meeting should be made public. Virtual participants should be able to cast live votes during the meeting in case the conversation evolves in such a way that the investor may change their views in the meeting itself. And then finally, a technical point is that, a universal proxy card, which puts all of the potential candidates on one slate, is probably a better way than having it potentially broken up. But so these are simply some ideas that we're putting forward, again, from a global investor perspective, to help frame the debate in saying, if we are moving on, if the future is going to be if the future is not going to be going back to physical meetings, and if investors have a reticence about adopting virtual meetings entirely, I think the formula here is what at least ICGN and its members are putting forward. So I will stop screen sharing now, and I will put it back to you, Iris.
Right, thank you very much, George. Can I invite any of the panel to comment on what you've heard? Do you agree with the hybrid model and some of the best practices that have been put forward? Anyone?
I think maybe I'll just start. I think, first of all, it's an excellent paper the ICGN put together, so I highly recommend reading it. It's a really nice piece of work. I think the jury is probably still out if which model will work for us. It's certainly not virtual only, and it may be a hybrid model. But then, as George explained, there are many things to mull over and see how they work this season and how they will work going forward. So I think it's remains to be seen what works in specific markets.
Right, anyone else from the panel?
Yes, I was going to ask whether the ICGN has a view as to who gets to choose how the meeting is held. So going back to the point about smaller companies or companies with smaller shareholder registers or companies where nothing very contentious is being put forward. Of course, there could be differences of view on that, but in those cases, if the company still wanted to carry on holding physical meetings and assuming for the moment that we've managed to fix our COVID problems, would the ICGN support that? I know one of the things that you mentioned was the difficulty we have that AGMs tend to come at the same time of year, so you're always facing problems about how you allocate the resources you've got to the particular companies that you're interested in.
Yeah, we haven't, Vanessa, addressed this specific question about who makes that decision, and it's good. I mean, and there, I think, as mentioned before, rules of proportionality do apply. But I mean, the interesting thing to embracing virtual technology means that traditionally it's very rare for an institutional investor to attend an AGM. You do it when something bad is going on, basically. But in this set of circumstances, it's not always, it shouldn't be always the necessity to go to when something's bad's going on. There may be other things as well. And the nice thing about the virtual structure is that, you could be sitting in London and you could start your day voting in Asia. You can spend the middle part of the day voting in the European Union, and then you could sort of conclude your day by voting in AGMs at night. I mean, and it's, and it's getting done. I mean, people will be doing that. There's a limit to there's still a limit to how many you can do, but it will enable people who haven't been in a position to take part in these to take part before, and hopefully that will enrich the discussion. But the question of who decides is, I don't know.
Right, I have two questions, comments from the audience for George. One, by the member of the audience who asked the earlier question, is that he absolutely supports this initiative from the ICGN and thinks that hybrid is the way to go, and hopefully the ICGN will come up with more granular guidelines in order to help companies set best practices. The second question would be basically with Boris's announcement earlier this afternoon, it looks likely that COVID restrictions might be in place for another 6 months or so. So this might interfere with AGM scheduled for April and May next year. And so what would you suggest in terms of best practices for companies that are planning these meetings for next year?
Expect the unexpected, I suspect. Hope for the best, plan for the worst. But I mean, the one point about, I appreciate the comment about ICGN's positioning, and I think but I think to Hans's point, the granular stuff sort of comes at the individual country level because they will have their own distinct traditions. And so what we're trying to do is provide a bit of an overlay to that. And was there a part of the question that I didn't answer, Irish?
Basically, what would you suggest for companies that are planning for for meetings scheduled for April and May next year?
Well, I guess what we're trying to do with our document is anticipate whenever what we call normality comes back, what might that look like? And, you know, I agree with Hans. I don't think of hybrid as a foregone conclusion, but I think that's probably a leading contender at this point in time. So I think companies need to anticipate that I wouldn't depend upon having a physical meeting this year, given COVID, but I think if it is possible, it should be tried. But then at the same time, we at least have had a year to sort of, for companies, and everybody's getting more fluent in doing the kinds of things that we're doing right now, so that that these types of events can be more effective. But I think just prepare for more of the same I'm not sure what else you can say.
Right, thank you. And I think with companies thinking about meetings now for next year, they would likely have more time to prepare for basically better engagement with the shareholders than the sort of short span of time that they were faced with this year. So hopefully, I mean, directors are thinking along these lines. And on that, I would like to invite my third panelist to come on board. And that is Dr. Roger Barker, Director of Corporate Governance at the Institute of Directors. Roger's full bio is again on our event registration page, and he's addressing the question of the pros and cons of virtual meetings from the point of view of corporations. So I suspect that he'll be speaking from the point of view of directors here, and that would probably be a good counterfoil to what George has talked about. Over to you, Roger.
Thank you very much, Iris, and thank you so much for the invitation. It's very good to be here. I've certainly been observing, as this issue of virtual AGMs has been discussed during this reporting season, that there's been a good deal of criticism from investors about them. Many, of course, are arguing that questions are being screened out by companies and that their overall ability to engage with boards and management is being reduced. And I think also some of the more cynical variety think that the pandemic is being used as a cover to actually downgrade the AGM altogether as a mechanism of board accountability. And they're also suspecting that even when the pandemic subsides at some point, and I hope that does happen soon, that companies are still going to stick with a kind of diluted virtual format as part of that process. And for example, I think that concern was very much underpinning the significant opposition to a virtual AGM expressed by investors at the Standard Life Aberdeen AGM in May, where a significant minority of shareholders voted against it. But there is, I think, also another side to this argument, which I would really like to put. And that is, surely we now need to really move with the times in terms of technology, and use technology in a way that will make AGMs more efficient and also more inclusive. I don't think there's anything inherent in the concept of a virtual AGM which implies that the result should be less accountability or reduced scrutiny of companies. And indeed, virtual AGMs offer many potential benefits, including permitting a wider range of shareholders and also other stakeholders from participating in the process. For example, it was noticeable to me that at the recent Marks and Spencer AGM this year, that in addition to the 1,500 registered shareholders that you had taking part in the live event, you had more than 15,000 people watching the AGM in the subsequent days, and about 8,000 of those were actually employees of Marks and Spencer. I do accept, though, that the way in which virtual AGMs are currently being managed may need some reform. Absolutely, some questions, some pertinent questions may be being filtered out, I guess, particularly by company secretaries who are kind of empowered to fulfill that role. And they're doing it from their perspective on the basis that the questions maybe lack relevance or are repetitious. But I can see that this can lead to some reduction in trust over the process. Now, of course, we're still in the early days of virtual AGMs, but I think that if we're going to try and increase trust in them, it might, for example, be useful to incorporate some form of independent arbitration in the coordination of virtual AGMs, including the selection of questions. Perhaps the sort of master of ceremonies could involve an independent expert who can balance investor and board perspectives. And I do agree with what Vanessa said. We do need, I think, to develop best practices in this area, and maybe in a future edition of the UK Corporate Governance Code, there will be some best practice recommendations incorporated. However, I do have to say that I feel quite a lot of sympathy for boards who feel that the current format of AGMs, both now and also prior to the pandemic, leaves a lot to be desired. Nowadays, most AGMs are primarily being organised for the benefit of small retail shareholders who represent only one source of accountability for companies, only one source amongst a variety of stakeholders who are all relevant. As we've mentioned, institutional investors with a substantial economic interest in companies typically have their own mechanisms aside from the AGM for engaging with boards. And even then, they often don't turn up to AGMs or may exercise their votes through proxies. Now, I'm not suggesting now that the small shareholder voice in respect of company performance is unimportant. However, I do think that the current AGM structure allows them to make disproportionate noise relative to their economic interest. And also, what about the voice of other stakeholders, employees, customers, suppliers, and so on, whose perspective on the company may ultimately be of much greater significance for the company's long-term success? Also, as has already been mentioned, I think that there's a problem with the current AGM format in terms of the pile-up of AGM meetings at certain times of the year. And Japan, I think, provides an extreme example of this. I mean, about 80% of the AGMs of major Japanese companies take place in the same week each year. And even in the UK and other countries, there's still a concentration of these meetings in certain months of the year. And I think that poses a real obstacle to meaningful accountability. But I would say that, you know, my overall view on this is that for the companies of the future, we really should think about shifting the focus away from the traditional AGM as the central, all-encompassing accountability mechanism for companies, and think about a system where the company engages with different stakeholders in different ways and in differing formats. And this will still include providing small shareholders with an opportunity to engage with boards and exercise accountability. But this could take place within the context of other events during the corporate calendar, including small shareholder days, stakeholder discussion panels with board members and executives. Of course, we still need a mechanism through which the process of shareholder voting on general meeting resolutions can still take place. But for the large multi-stakeholder organizations of the future, I do think that there is a need for innovation and some fresh thinking in terms of how we achieve meaningful corporate accountability. Thank you.
Right, thank you very much, Roger. I really think this has thrown into the mix a very, very interesting question as to what formats of corporate accountability should there be. And if we are serious about moving, you know, increasingly towards kind of stakeholder-oriented capitalism, then that there is certainly a place for thinking about how company law might facilitate some of these changes without actually losing accountability to shareholders, who are an important constituency anyway. So can I invite comments from the panel? Right, Deirdre?
Thank you. That was a very interesting presentation. And just echoing Iris's views there about the stakeholderism, I think that was a really fresh perspective. And I think it's one that's obviously growing in importance in the UK. It has been fascinating to watch how Section 172, which is the duty to act in the interests or to promote the success of the company, initially was, I suppose, laughed at maybe as being a sort of paper tiger. you know, that you had a duty to have regard to the interests of other stakeholders, but you could just minute that you thought about them for a moment and move on. But now I think it's interesting that with Section 172 reporting, we are actually seeing companies having to engage more with employees, with the interests of suppliers, and to actually account for how they are actually taking into account stakeholders' interests. Obviously, it's still early days in terms of how that evolves, but what you're saying is maybe, you know, with this move to increasingly think about stakeholders' interests, that the AGM needs to kind of move out of antiquity and to take account of that, and in terms of not just reflecting the two organs of the board and the company in general meeting, and reflecting these other stakeholders. So I'm heartened to think that you've actually sort of been thinking about that. How it's to be done is, maybe as you say, is there a right for others to attend and to participate? I'd be interested to know what your view might be.
Well, I thought it was rather worrying, wasn't it? I think it was perhaps the Tesla AGM last year, where he didn't allow, for example, journalists to attend. So you had to be a shareholder to attend, which was, to me, a very retrograde step in terms of accountability and transparency. But yes, I mean, I do think that this sort of one-size-fits-all approach to accountability, that somehow through one meeting we're going to achieve all of our engagement and accountability purposes, needs rethinking. I mean, just as with corporate reporting, I think you need information and engagement which needs to be tailored to the specific audience, and I think general meetings are no exception to that.
Right, thank you, Roger. Can I invite Hans Kristoff to make a comment first, after which Vanessa has a comment as well.
Yeah, thank you. I mean, Roger, very convincing as always. And I think it's really good to think about stakeholders more widely. I think the real challenge is what's the alternative. That's one part, and the other part is, I mean, if you're thinking about the clients, the pension funds we are representing, then you're not looking just as not just looking at them as investors, but they're also employees working for large companies. So there are people who may have listened into the Marks and Spencer AGM. There may be people working for Siemens. So there's an overlap here. There are also citizens. They are paying for the bailout of the economy, for the COVID help, and they're also part of the wider environment. So they are representing stakeholder interests. And I think that's very much reflected certainly in our stewardship activities that are focused, for example, on climate change. And climate change has been one of the key topics in spite of the pandemic this year, with even Barclays having not one shareholder proposal on climate change, but actually having a proxy fight on climate change proposal between management and investors. So I think AGMs are actually used much more widely on stakeholder topics. But I think it's a very interesting challenge to think about how to reform, and also how to bring stakeholder views more systematically to boards and into companies. But yeah, thank you.
Right, thank you, Hans Kristoff. Vanessa, can I invite you to make a comment?
Yes, I was thinking about how it might work, and I can see that from the company's perspective, having different ways of engaging with the different stakeholder groups could be attractive. But I suppose what worries me is, it seems to me what we're all grappling with, but we're not very good at discussing, is that directors of companies have to balance competing interests. So they have to balance the interests of the shareholders against the interests of the various groups of stakeholders who themselves may have differing interests. And so I feel rather nervous at the idea of allowing us to get away from a meeting once a year, which is at least an opportunity for all these differing interests to be thought about and reconciled. And perhaps if we wanted to be really radical, we might think about, well, should there be a right for stakeholder groups to participate in that meeting and make a statement about it. So feed into the meeting, because if we just separate out the different interests, then every particular bit, the temptation will be for them to think about their own particular interests to the exclusion of the other interests. And as I say, I think we're expecting directors to do a difficult job of balancing competing interests with not a great deal of guidance for them as to how they are to do that. And that's one of the reasons why I think the reporting on the Section 172 duties, which gives directors an opportunity, if they want to take it, to explain how they think about the company's business and how those differing competing interests mesh together to produce what the company is trying to achieve, is really important. And for me, that's where our discussion should be.
Right, Roger, would you like to respond to that, or shall I give you our audience's question?
Yes, may I respond very quickly? I very much take your point, Vanessa, about balancing interests, but of course that is part of the director's job, isn't it? And even within the shareholder constituency, there are many different interests, so which have to be balanced. The thing about the AGM, of course, is that it is quite exclusionary at the moment, because it's only shareholders who have a kind of legal right to attend. So it's and also the other thing which it makes me feel it's a very shall we say narrow perspective on shareholder interests, is that it really is the theatre floor for the small retail shareholder who has a very distinct perspective perhaps on the company, and that gets a disproportionate volume at these type of events. So what I would like to see is a more sort of balanced assessment and voice for different stakeholders and different shareholders.
Right, thank you, Roger. One of the suggestions that our audience has made is very interesting. Basically, a member of our audience is considering whether or not the annual general meeting is an archaic form of engaging with shareholders, and whether we could go towards a system of, shall we say, continuous decision making. So the suggestion is that proposals and agendas of the meeting can be prepared and circulated at different times throughout the year. And you won't need a particular meeting to decide on these. And as long as the company can then confirm how the votes have gone and which resolution has been adopted or rejected, that would give shareholders a sense of how decision making has been done. Do you think this sort of system of continuous decision making might actually be helpful, or do you think this might be just a hassle for directors?
I think one needs to find a balance, and of course there are some ways in which directors actually do that currently, don't they? So that they do things like, for example, declaring an interim dividend without actually getting shareholder approval. But I don't think. I think it could, and of course, shareholders at any time have the right to call some kind of extraordinary general meeting if they've got something very important that has to be discussed. On the other hand, though, I think shareholders have a distinctive role, don't they, in a corporate structure, and that is not to be running the company. That responsibility is delegated to the board of directors and the management. And so I think, we shouldn't be encouraging shareholders to play some kind of micromanaging, real-time micromanaging type role in the company. We need directors, of course, hold them to account for that at certain points, but let them at least do it.
Right, okay. Thank you very much, Roger. And since you mentioned the importance of, oh, sorry, George has a comment.
Yeah, I just wanted to say, I think from an investor perspective, that it's an interesting suggestion. I think it would be absolute chaos. I think you need to look at these issues altogether holistically, and to expect an investor, much less, to keep all of these thought processes live in the year, it simply wouldn't work. I think Roger makes good points about some of the failings. And I think that the key is not throwing out the baby with the bathwater, as Hans said. What is the alternative? and I think engagement can and should be amongst all stakeholders that are relevant, and probably 12 months of the year and not just packed into a week. But the distinguishing feature about the AGM itself is this is where fundamental decisions are taken and ratified. We're electing board members, approving capital transactions, approving the accounts. And this is where it all comes together. And I think that, yes, you can have other opportunities that can inform these votes, but I think having all of this happen at the same time in an AGM is again, as Hans said, if there is a better alternative, let us know. But I think that, you know, the AGM is going to be with us. How can we make it as effective as possible without compromising any of the stakeholders, including shareholders?
Right, thank you very much, George. On that note, can I invite Kristoff, our next panelist, to come on board? Kristoff has been asked to address a question on technology, basically how technology such as distributed ledger technology might have the potential to revolutionize shareholder participation and corporate accountability. So Professor Kristoff van der Elst from Tilburg University has written extensively on this area, and he has some very exciting publications on DLT in particular. I'm not quite sure if this is what you'll be talking about, but I'll hand over to you, Kristoff.
Thank you very much, Iris, also for inviting me. I'm happy to participate in this interesting webinar. Let me also do some screen sharing to illustrate some of the issues very briefly about problems that I'm investigating, and to see to what extent indeed DLT can be helpful in solving these issues. I hope that by now you can see my screen. Yeah, okay, perfect. So what I would like to do briefly is first mention you two problems that I encountered. And this is already a preview of research that I'm currently performing. And in fact, don't worry, this is not the UK. This is a sample of large listed companies in France that I've selected in order to find out what happened due to COVID with these AGMs, both at the level of the participation of the shareholders as well as at the level of the votes. Some of these companies, more or less voluntarily, disclose information about the different techniques that are used to participate and vote at these meetings. They can either attend in person, they can be represented, they can vote through a proxy to the chairman, or the majority of them obviously voting by mail. Now, as you can see, overall, like also illustrated already by Roger, there are a huge number of shareholders that actually do participate in big companies. In 2019, it was approximately more than 7,000 shareholders through one of the mechanisms participated, even up to more than 8,000 during 2020 COVID season. Now, an interesting feature in France was, well, interesting, is that it was simply forbidden to attend the meeting as a shareholder in person. And this is not only the case, I'm simplifying things a little bit, was not only the case, by the way, in France, it was the same thing that happened in Belgium, the same thing that happened in the Netherlands and some other countries in continental Europe. So the only two options that remained were either give a proxy to the chairman of the board, either to vote by mail. And as you can see, in fact, many shareholders did. In particularly, they opted for voting by mail. And consequently, whilst those shareholders that attended in person in 2019 still made a significant part of the total votes that had been issued, it completely now shifted to voting by mail. One remark here also, in 2019, the difference lies also a little bit compared to the UK. The difference with France is that there are still a number of companies, large listed companies in France with concentrated ownership, and hence some of these shareholders with concentrated do actually participate in person. So it's a huge number, a couple of hundreds of small shareholders, and then some larger shareholders participating. And hence you have, as you can see on the right-hand side, this situation completely changed in 2020, all going to voting by mail, a little bit by proxy to the chairman. Now, so in fact, you lose for sure if you now get rid of a general meeting that actually physically takes place, the attendance of persons directly questioning the board, and so on and so forth. Now, is it then compensated? What they did in France, like in many other countries, they emphasized the possibility to raise questions up front. So I studied also in a number of companies disclosed how and when and how many of these questions were raised. And as you can see, I did it for three, just as an illustration, three larger French companies. It seems at first hand that the number of questions raised before the meeting, addressed during the meeting, which was held online and answers were provided online, that there was an increase. But in fact, if you take a look at the right-hand side and take, for instance, 2018 compared to 2020, it is in fact not a large number of shareholders that make use of this question right up front. It's only a couple of shareholders, and in all honesty, these are some organizations that I know buy one share to attend the meeting to raise a lot of questions. And this year they raised simply more questions. I know in the US sometimes they are identified as gadflies. Well, you have them all over the world, and you see them raising sometimes tens of questions. So in fact, this opportunity to upfront come up with question rights that will be used and addressed during the meeting, it doesn't seem to directly help. That's the first element. So probably it cannot directly replace the right to really also during the meeting come up with questions. There is a second, so there seems to be also that COVID-19 does cause a little bit of a problem to simply, at that moment in time, abolish the meeting if it is not possible for shareholders to attend anymore. Second thing that I'm not going to develop in all details, that is, I would say, the second problem that we still encounter is the problem of the, I would say, back office of trading. Now, according to, for instance, the European, even a regulation, if a company is issuing shares, it must provide the central securities depository the shares. So that is a mandatory duty that is in fact also embedded in a regulation, so very hard. That's one hand side in a very simplified form. Now, on the opposite side, if you have a buyer and a seller, they of course go to the stock exchange to buy and sell shares, which is nice. And there approximately it ends for the investor and the shareholder, and it also probably ends for the issuer. However, behind the scenes, a lot of things happen. Due to, in fact, modernization that started after the Second World War, instead of really exchanging the shares, they were deposited, and you have all these intermediaries that were participating for the clearing and the settlement. And also the ownership system in all countries differ. In the UK, they use the trust system, but in Europe, they sometimes use omnibus accounts and sometimes individualized. So many different systems, in fact, do exist. And consequently, also, this is problematic for going fast, for identifying who is actually the shareholder, and so on and so forth. And actually, this is also causing a number of problems because sometimes mistakes do occur. Okay, if we know this, can at least also there can be thoughts about solving part of the issues. And then I would like to say something about distributed ledger technology. Be aware, it's not that I really also going to say that we immediately have to move towards something that resembles this Bitcoin thing behind the scenes for AGMs and so on. This is not going to work immediately. But at least you could start facilitating by using a distributed ledger technology or other techniques. You have also JIT and some other techniques that are available to, in fact, make a more closer and direct link between, on the one hand side, the shareholders and the company, eventually with only one intermediary, who it can be, I leave it open for a minute. It can be a CSD, but it could also be the stock exchange, to also, in fact, guarantee that actually it is indeed the shareholder. But by then have a much more direct link between shareholders and the company in order to increase the effectiveness and in particularly also to provide an equal access of all information. Because that is a key issue that I also have heard both from Vanessa as well as from George, and that there are filtering questions, for instance. Well, if you have a question and a shareholder and you're registered, you can put into a block also these questions. So there is no way out that this can be hidden, because through this blockchain, I can say everybody that is by the permissioner entered into this blockchain permission chain can see the questions and can also understand how the company is addressing the question, because obviously this information can be provided by the company. So that is, of course, also maybe helpful in order to overcome a number of other problems that nowadays what you also see is the problematic situation, in my opinion, is that, for instance, there are one-on-one meetings. There are also sometimes institutional investor meetings with the company separately from all other ones, so that not everybody is informed in a similar base. Obviously, this will not happen overnight. Yeah. One of the leading examples that I might add here is that currently, at least, it has been tested in a number of cases. I know Kasbank did it in the Netherlands. Banco Santander started to use that or tried it also in Spain. Some other companies did. But in fact, they see still that it is quite complex, transforming general meetings completely into this framework of a DLT. At least ASX, the Australian Stock Exchange, is in fact now preparing the transferring towards this distributed ledger technology, which would start in spring 2022. One of the major advantages, at least that they have, is that ASX is also behind the scene the one that is responsible for the clearing and the settlement. And that is, for instance, indeed what I see as a current problem that is difficult to overcome in at least European context. And as it is a regulation of 2014, obviously also already implemented in the UK too. But hopefully this can be showing that there is a way forward to start making use of distributed ledger technology to in fact invite many more to participate and have them treated in an equal footing. Thank you very much. I again stop with sharing my screen and go back to all of you. Thanks.
Right. Thank you very much, Kristoff, for this very fascinating presentation. It is interesting to know that mail was the preferred means of voting, and hopefully DLT might change what people think about getting connected with technology. Right, I'm just wondering if any of the panel might want to respond or comment on what Kristoff has just said. Deirdre?
Thanks, Iris. That was really interesting, Kristoff. Especially, I was particularly fascinated by your idea of solving that issue that we've all been touching on, of the problem of filtering out questions and using blocks to actually, I suppose, code in the questions. And then I suppose you're expecting then maybe that all questions would have to be answered visibly, and that there would be, that this might replace an AGM or would take place as the AGM. I'd be interested on your views on that.
Ultimately, I would like to go a little bit also in the direction that indeed you can then have questions or items on a more permanent basis to be solved. And I heard already George saying this is going to be a catastrophe, but it is sometimes also a catastrophe in the opposite way too. So yes, sometimes it can help. And let me illustrate and give you an example that I personally also know of, that in my opinion also the current one-way hit at one AGM doesn't work neither. Recently, I know that one company, for instance, the board of directors in a country had a right to co-opt directors until the next meeting and have it approved. Well, then it must be approved. That director that was co-opted already standed down before the AGM took place. Well, the AGM had then to, in fact, agree upon the co-optation of a director that already disappeared in the meantime. What's the usefulness of that one? So at least a number of items, I do believe that in fact, due to this distributed ledger technology, not by next year, there are energy problems and so on and so forth, but could indeed at least replace part of the AGM. But certainly in the meantime, I would not immediately abolish, in fact, the possibility of organizing even a physical AGM, in particularly also to have a discussion taking place on the floor and exchange views. But maybe towards the future, if it is indeed proving, for instance, in Australia, that it could be a good replacement, maybe yes, it could end up that you no longer need these physical meetings.
Right, can I ask Hans Kristoff to make your comment? I think you were ready to do so.
Yeah, just one thought I thought was really interesting, and maybe also thinking about how one can connect, and that's a big topic also here with stewardship code and pension regulation around how one can collect the pensioner, the ultimate beneficiary, to the company and ensure that more information is going all along the investment chain. And I think that's probably sort of building on the model you have developed, because then one could actually close the chain, as it were, and really ensuring that the company is hearing from the people they should be ultimately responsible to.
Well, thank you very much for this question. This is a very interesting one. However, in a first step, I don't think this will be possible, in all honesty, because of course, like it is with mutual funds, like it is with pension funds, you have quite often thousands of participants, which also have different interests. I'm, for instance, a member of one of the biggest pension funds also in the world, but which is ABP in the Netherlands. I absolutely have still a time horizon, which is, let's say, 2 decades, whilst the number of retired pensioners would say, so no, we're on it now. So I think that for the time being so far, it needs to be first addressed at the level of the pension fund, the mutual fund, and then the mutual fund is then representing then towards the company, the investee. At least in a first step. But nothing, for instance, prevents then that ABP or pension funds is setting up a DLT system to hear what the beneficiaries have to say. That can be done. But in a first way, I think that we certainly have to separate these two things.
Right, thank you very much, Kristoff. I haven't received any questions from the audience, and I suppose that this must be because they completely agree with this technological revolution going forward. I'm just wondering if you mind indulging the chair in a question, which I have for you, which is, why do you think that the two DLTs will have to be separate, meaning basically the investment fund and the beneficiaries being one, and the fund or the asset manager sitting with the companies in another? DLTs can actually, I mean, the public permissionless ones have become really, really huge with millions of nodes. So would it not work for your permissioned blockchain?
Well, probably it can. Maybe I was thinking a little bit too much like as a lawyer now, already being a little bit afraid. So, well, wait a minute, how internally within a mutual fund or within a pension fund, one is thinking about its relationship with an investee company, not necessarily should be familiarized with all the other shareholders of this investee. So in fact, I could be open, but I can imagine also from the legal perspective that there might be issues why not immediately share and come so far as it can work forward with one voice from a mutual fund, from a pension fund as a first step. Maybe yes later onwards, but yes, I have some legal hesitations, but I can't pinpoint immediately where it lies. But for in the first step, I think we have to be very careful about that.
Right, okay, I agree. I don't think the rest of the panel have anything to add. Or Vanessa, yes, sorry, yes.
I can see real benefits in using distributed ledger technology to help us. One of the things that we have grappled with in the EU for a long time is exactly what you were saying about the complexity of the chains between the company, the custodian bank who might be recognized as the shareholder, and then at least one or maybe more than one layers of people until you get to someone who we as company lawyers would recognize as being the investor. And I have always thought it should be possible for the person the company recognizes as the registered shareholder to identify through that investment chain who they nominate as the person who gets to take the decisions on voting and things like that. And then as long as the system tells the company who that is, you can set the system up so that the company provides the information to whoever the registered shareholder has set as the people to have that permission, and also to accept instructions from them on voting. But I do think you're right that where that investor themselves is a trust or some other organization which is having to balance a whole load of competing different interests. So trustees of a pension fund who, as you say, are having to manage a whole raft of assets, both for people who are getting their pensions paid at the moment and people who won't get their pensions paid for another 20 years or so, I think it then becomes too complicated to give those beneficiaries the right to input into the system. But you could also use the DLT technology to pass on the information that the company provides, and maybe for the investor, so the pension trustees or whoever, to gather information as to what their beneficiaries think as part of their decision-making process. So I think it has tremendous possibilities, but we're never going to get away from the fact that there are going to have to be some hard decisions made about how you balance those competing interests and things like that.
Absolutely, yeah, that's, but in fact that more or less could be, although definitely not identical, boiled down to a little bit a similar problem that you can encounter in companies, the 172 Companies Act, that the board of directors should take into account all the interest of the different stakeholders. And I summarize, I know a little bit too much, but that's a little bit a similar thing.
Yeah,
so that I agree. For the remainder, I fully agree with you.
Right, okay, thank you. I don't see any other hands up, and so let me now move on to invite my next panelist, Dr. Hans Kristoff Hirt from Federated Hermes Investment Management. And the question that we pose to Hans Kristoff is how the COVID-19 pandemic has affected shareholder stewardship or engagement in particular, as Hermes is very well known for. And further, I think I also posed a rather cheeky question on technology as to whether as an asset manager, you think it might be a good idea for shareholder participation to be truly flattened out to include beneficiaries in a kind of blockchain type structure. So over to you, Hans Kristoff.
Thanks very much also for having me. And I think the tech question was probably better answered by Christopher, who's the expert. But I also try to add to this. So as you said, Federated Hermes is probably best known for stewardship work or engagement work, which includes voting. And voting is a very important part, but there's clearly much more than voting. We have actually a dedicated stewardship team of more than 50 people looking after 1 trillion of assets under advice, including for many pension funds here in the UK, but also all around the world. So the question, there's a fundamental belief that engagement matters, and there's more and more empirical evidence to show that there's a link that investor stewardship matters for the performance of companies. So against this background, the potential disruption from the pandemic was, of course, very, very concerning to us as a firm, and to me personally, being responsible for that part of the business. But a few things I think addressed this concern. One was that we had quite a lot of pre-warning, effectively, because our team is very international, and we also engage in Asia, where the disruption of the pandemic hit many months early in the first quarter, and we also quite used to working virtually in engagement with Asian companies and with US companies across time zones. But nevertheless, it was what we put in place is really a monitoring system to understand what is the impact of the pandemic, of the lockdown for engagement purposes, and both in terms of how many meetings are taking place, is it more difficult to see the chair or the CEO, but then also the quality of the interactions. And I think there were two big phases. The first phase was so the initial period when Europe and then the US were in lockdown, that there was I would call a period of uncertainty where companies were very much inward looking and really a little bit in survival mode, and some of them really looking at, do we have enough capital? Can we keep the operations going? And probably during that period, less focused on other stakeholders, including investors, and also with limited bandwidth to have conversations. But this probably only lasted a few weeks, and then something, it almost seemed like we're switching seamlessly into the virtual world, and this is clearly documented in terms of the interaction, numbers of interactions, seniority of interactions our team was having during that time, to the extent that some of my team members commented and said they actually had the feeling that some of the most senior people, so directors, board members, actually seem to have had more time during the pandemic than previously. So there was probably more access and more interaction than in a comparable setting. The voting season, I mean, we talked about virtual meetings, I come back to this, was as intensive as always. I mentioned Barclays as an example, where there was shareholder resolutions around climate change, but also this was really true all around the world, that discussions were intense with companies and that the senior people made themselves available as in previous years. What we did recognize was very much a shift in what is actually being discussed between investors and companies. And we try to contribute to that discussion by sending in April, so very early in the lockdown, sending an open letter to companies and setting out our expectations for dialogue and setting out what we think are the important topics. And very fortunately, I think many companies agreed with what we thought were the important topics. So there was a shift from financial and operational resilience very much to discussions around stakeholders, which was new for many companies, specifically, I think in the US, their stakeholders is still, let's say, a relatively new concept in discussions. So that was important, but then also the role of governments and the role of governments is coming to the rescue of many companies and also injecting huge amounts of money in economies and basically coming to the rescue of the whole system. And what does it then mean for companies as part of the wider economy systems? Things like the social license to operate formed really for the first time, I think, across the board, part of the discussions. And then we also had lots of discussion about risk management. I mean, pandemic it's not a black swan risk. Many companies had pandemics on their risk register, probably not quite to the extent that it played out with lockdowns of entire economies. But why were companies so unprepared for what played out over the last 6 months? And more critically, what can be learned for future crises, be it pandemics or the climate crisis accelerating? So definitely a shift in topics. In terms of quality and accountability, I would say it's to date, it's okay, the quality of the dialogue, but it's also built on social capital, very often on relations with senior people. It's very difficult to start a relationship, a trusted relationship, starting that virtually. So we have been, it's similar to the work with colleagues in the office. You're drawing on social capital you have built up sometimes over many years, and the same will happen for us and colleagues, and the same will happen between investors and companies. Much more difficult to start with a company from the beginning in a virtual mode. So I think there will be disbenefits. There are disbenefits from working from home, and it will be more difficult as we're going into the next 6 months of the pandemic and probably beyond that. AGMs, we covered it a lot. I just want to reiterate that in my experience over the last 16 years, having participated in AGMs pretty much all around the world, they have often played an extremely important part of engagement success and stewardship success. And part of it was being there in person, having in-person discussion, being able to get up, ask a question again and again, getting other shareholders on board, speaking to the whole board of directors, and that has worked in many markets in a really positive way. And then we talked about retail shareholders. And in a market like Singapore, some of the best questions are asked by retail shareholder associations, and that's also something that I think we need to keep in mind when just looking at the AGMs here. Yes, institutional investors are more rarely visiting AGMs here, but it has also changed over the last few years, particularly with other stakeholder and climate change becoming more of a topic. It has become a more regular feature also here in the UK. And I think we want to get to a model that combines the best of two worlds. That's again a little bit like combining working from home and working in the office, combining the physical element, which is important in some cases, with the best element of virtual meetings. I'd like to finish with one comment on which we started to touch upon, on how we can ensure more beneficiary participation. And I think that's really one of the challenges we need to address as an industry. How can we get at least more views from beneficiaries and factor that into our work as investment managers or as pension funds? And we have very close interactions. We're doing surveys, we're doing in-person meetings with the pension funds we work for, and actually in one or two cases also meeting directly with beneficiaries just to hear what for them are the most important stewardship topics. And that's extremely helpful, insightful to guide our work. And we are also actually working with a technology provider to see if we can get more input from beneficiaries directly for our voting decisions. And of course, you have the problems about people, maybe the ones who are shout loudest get their views across, but at least it's an input we can look at and we can take into consideration in the future. So that's also something we're working on, and distributed ledger technology is an exciting part of it, and something we need to consider on this. So I think I finished. I'm out of time too, but very happy to answer questions.
Thank you very much, Hans Kristoff. Can I invite the panel to comment? George, please. Yes, George? You're muted.
Sorry, I always do it. Thank you, Hans. Quick question for you. I think the beneficiary, the end of the asset chain, I think we all agree is important. And it's really good to hear that what you guys are doing. I think that's probably pretty innovative. But what happens if you go to one of these meetings and you get advice from your beneficiaries that conflicts with the investment mandate, the investment management agreement? How do you react to that?
I think we need to moderate the different inputs. So I think that's we also fiduciary, and that comes back also to the question around directors and how they manage the different interests. We have a clear mandate to act in the long-term interest of the assets we are managing or representing. So that's I think the guiding the North Pole in decision making. But then there can be very different views on how you can best get there, and we have a large group of clients to moderate, so that there's a little bit of moderation. We're trying to get academic evidence, empirical evidence to guide us in the right direction and making the right calls when there are conflicts.
Right, Vanessa?
Yeah, I was just going to add to that I think it's really important that we get people to recognize that there are those conflicts. Because I think, as somebody was saying, when you have a particular point of view, you sometimes get very focused on your own situation and what it is you care about. And you forget the fact that the pension fund trustees or the directors, whichever group it is trying to do this difficult job of balancing these differing interests. But it seems to me that if we can find the way to get people to appreciate that that's what we're doing all the time, is we are balancing these differing interests, and trying to make the right judgment calls and explain to people we can't always do what they particularly want us to do, but here are the reasons why we've come to the conclusions that we have. I sort of think that maybe ought to help things. So I really think that finding ways to engage not just the investors and the companies, but the public and the beneficiaries is really important.
Right, thank you, Vanessa. I think on this note, if you don't mind indulging the chair, I mean, I've been very curious as to how the implementation of the new stewardship code has been going in the asset management industry. I mean, in the sense of, are there going to be kind of new and more standardized contractual mandates with asset owners having more scrutiny, being able to ask, you know, for more in terms of ESG, for example? I mean, are we seeing that kind of a trend?
So definitely a lot of focus, and that helps I think the stewardship report 2020 is excellent, with the focus on more different asset classes, also focus going away just from processes and policies to actually report on outcomes and bringing together, really saying stewardship input into an investment. So I think the industry is getting its act together on that, and there's a lot of work going on. How can one best report and actually document how stewardship makes a difference, and then also how stewardship helps better investment decisions and better investment performance. I think you touched upon the critical questions, and coming back to the investment chain, I think it's up to asset owners really to ensure that stewardship requirements are part of investment mandates, and that's the easiest for trustees to ensure that their asset managers are doing a decent job. And I think again the ICGN is working on update to the model mandate, which is an extremely important piece of work to be clear from the beginning. Once the mandate is awarded, what are the expectations, what are the reporting requirements? But apart from that, there's a lot of thinking going on, and the UK is setting a welcome trend again, unfortunately with less influence in the future in the European Union.
Okay. Roger has a comment or question. Yes, please
yes,
go ahead.
Yes, Hans Kristoff, I wonder if you feel during the pandemic, this has actually put back the influence of shareholders and institutional investors as a key influence over companies. Because I'm just thinking of the fact that during the pandemic, the emphasis really has been all about sustaining companies as organic entities, so to speak, and in particular maintaining employment. And shareholders have been asked really to take a back seat, haven't they, in many respects? They've been asked to swallow cut dividends or lower dividends. They've had to accept delayed AGMs. They've had their preemption rights, for example, reduced. I mean, do you think that this represents a kind of a permanent setback for investors, or is this just a temporary phase?
I think, I mean, the fundamentally the pandemic is a crisis, but there's also real opportunity, which I try to express earlier, and which we try to express in our letter. I mean, the funds we represent, if you're looking at a pensioner, then this is a stakeholder and is part of the wider system. So what if we can learn one of the lessons of the crisis, that it's all interconnected, companies, employees, citizens, and investors are part of the system. So I think if we can learn one of these things, this interconnectivity between the parts, and that they're all connected and they are successful or not so successful together, then I think that would be a useful lesson to be learned. I think the discussion have shifted, and there is a danger that the quality of the dialogue, unless we get out in the relatively near future and have in-person discussions again, I think the dialogue, the quality and the impact of the dialogue will suffer at some point.
Right, thank you both. I have not received any questions from the audience, and so I'm going to let Hans Kristoff off. And shall I call upon, oh, sorry, is George having, yes, George would like to make another comment. Yes.
Great, thanks. Yeah, I just wanted to sort of follow up on both Roger and Hans's point. I think I'd like to look at the crisis as sort of one reality and post-crisis as another reality. And I think what happened in the crisis, for all the reasons, we focused on the sustainability of the corporate entity itself. I forget exactly how you put it, Roger, but it was beautiful as an organic entity. And I think that's absolutely correct. And then I think the point has been made several times that during this period, investors, hopefully willingly on the most part, have accepted compromises from the status quo, compromises such as preemption rights or delayed meetings that otherwise would make them uncomfortable, but we all are in this together. But I think what we're trying to now anticipate is once, and hopefully this will be sooner rather than later, although with today's news and maybe not, but once some semblance of normality comes back, do we go back to the old ways? Or do we accept some of the compromises like preemption rights that we took on for very pragmatic reasons in the short term? What is the long-term balance? And I think some things are going to shift back the other way. Preemption rights, I think, is going to go back away. And I think the big question here is what to do. What we have learned, and I guess don't waste a good crisis, is that there are ways in which technology can advance connectivity in a way that we're just experiencing right now. I think we need to work with that, and I think the future will be different from the past. And Christopher, I don't think we're necessarily phobic about technology. I think the theme is to embrace it, but under the premise that it can't dilute or weaken the rights of shareholders. And if technologies can get at that, great, but I think it needs to be demonstrated first in practical terms and not just in the abstract.
Right, thank you, George. Does Hans Kristoff want to respond any further to this comment?
No, I think that, George expressed it very beautifully. I think taking the positives out and looking forward, and I think the stakeholder aspect is, which Roger made earlier, working that in a greater focus on stakeholders and thinking about how the views can be delivered into the company decision making ought to be one of the lessons learned and one of the steps we can make forward.
Right. Okay, thank you very much. I think it now leaves me to call on our final panelist, Professor Deirdre Ahern, Trinity College Dublin, who will join us and discuss more broadly the issue of technological opportunities and corporate accountability and against the big backdrop of EU law and harmonization. Over to you, Deirdre, for this massive job.
Thank you, Iris. It's a pleasure to be with you, and notwithstanding the challenge you've just set me. I suppose it's helpful maybe for me to try and maybe take a bit of a bird's eye view based on all the really interesting perspectives from the other panelists at this stage. Well, being an academic, I suppose it would be remiss of me not to mention maybe some of the ideological values that maybe are inherent in corporate law in theory, if not in practice. Maybe just to begin by saying that when we think about accountability and AGMs, it goes back to this notion of the shareholder organ as being this accountability organ. And in fact, it's the shareholders who rather nicely delegate the day-to-day running of a company to the board. Although that is obviously a matter of invariable practice at this point that is well entrenched. And they retain an oversight function in certain circumstances, but there's also a transparency function to the AGM as well, and a voice function that is notionally there, at least in relation to an opportunity for shareholders to comment on matters like the company's performance, to exercise views in relation to the management, remuneration, and board members. That, I suppose, that accountability function is, I think, as we've all noted, somewhat idealized. We've all noted how the AGM is probably creaking at this stage in relation to the kind of old school values that it espouses versus actual reality, where, you know, say for example, as Kristoff mentioned, we have a preponderance of advanced voting, and I know Roger sort of also referred to how the actual reality of AGMs in practice is quite different. So we may not have that much accountability. So I think we need to start with the fact that intractable accountability deficits are maybe inherent in the system, and technology may impact on those to some extent, but they exist anyway. But we are, I suppose, having an opportunity to shine the light on what's occurring and to think about what might be for the future. So I suppose technology, in my view, may assist in facilitating voice, but it will not necessarily take up of voice if people are feeling like being passive or not interested, if they're happy with how the performance of the company is. Technology may not change that. We obviously have heard that remote participation may help those maybe cross-border shareholders and others who do want to participate. But again, we're still back to that idea of, do people want to participate or do they not? So I guess as an academic, we would call that, you know, shareholder apathy or the free rider problem. Those things are there, or what Lord Miners referred to famously as the absentee landlord's problem. So yes, technology can facilitate, but I don't think it necessarily changes fundamentally corporate accountability. There are, however, I would say, some opportunities to promote shareholder participation that I do see. And we have talked about, first of all, the importance of actually being able to identify who the shareholders are. And I suppose Kristoff would probably be the expert on blockchain or DLT technologies and how maybe in the future that might make it easier to identify shareholders if you had a shareholder register, for example, that was DLT based, or as they've done in, for example, Delaware. And I know it's also been, there have been some cases in Europe that Kristoff knows more about than I do, but I mean, those sort of things do help. So I guess in relation to the AGM then itself, well, what can we actually, I suppose, hope to gain? Well, shareholders may be able to vote more easily if we were able to use the mechanisms that Kristoff referred to, if there is a more seamless way of using technology for those who want to use it. Blockchain is the future, I suppose, or alternatives. And I think, well, it's not going to happen today or tomorrow, but it's certainly something that I think we're going to see in the future. I was asked to also consider risks, and I suppose there are definite risks in relation to any technology. So one of the things we know about blockchain and indeed any technology is that the concept of garbage in, garbage out. So if you're putting stuff in and data and or you're using AI, etc., but you get something wrong in the programming, or you have obviously got problems. So there are risks as well as opportunities. So that's something in terms of needing auditing of any data that will be used in that way. I was just having, I suppose, been thinking about this as well, and I'm kind of giving some thought to AI in another context of ESG at the moment, in a different context. I do see that maybe in the future, it might be possible to vote using a smart contract, whereby, you say if that, then, so if we like the ESG sort of reports, we could sort of automatically say we're going to vote yes to this or that. So we may have more automated kind of ways of being able to sift information. We may be using more AI analytics in proxy advisory services and others who are making decisions. I think there will be a lot more of that going on. So smart contract protocols may well come into play as well. I think that EU law as it exists can withstand that. I mean, it provides for electronic voting. So I don't think there's any difficulty in relation to how people arrive at the decision to vote, and it occurring based on some sort of pre-programmed formula. That is possible, I think. The other thing I suppose, thinking about, particularly having participated in an abundance, if I can say nicely, of Zoom meetings at this stage, we may know that we have these chat functions, and you send your message to everyone and you hope it's not the one you meant to send to one person. Yes, but I suspect that companies would not be particularly desirous of having chat functions at their AGMs, whereby shareholders can get very cozy with each other and possibly, gang up or engage in rapid fire discussion of what they think of the incumbents, or that would be a sort of shareholder activism that we have not seen before. And I would love to see it be put into EU law that, if an online meeting is held, an open chat function must be available. But I somehow doubt that will happen because of the requirements that companies are allowed to have the orderly functioning of the meeting dictate that probably won't be allowed. But I nonetheless think it would be wonderful to see. And certainly inter-shareholder communications and activism would probably take on a whole new meaning. Just to maybe kind of return to the actual wording of the Shareholders' Rights Directive, where, we started there with Vanessa's presentation in a way, which was the implementation of the provisions into the Companies Act 2006. And then she noted, I think particularly that, it's kind of facilitating real-time transmission. It doesn't say that it has to be video. Do we think that maybe the EU law should say video is required and not just audio? Possibly we should require maybe video. Yes, it may be more expensive, but not that expensive in this day and age. It requires a real-time two-way communication. It's a hybrid model. It's not envisaging an online-only model as yet. We talked in the room about this as to whether or not we should allow an online-only model. Just when I was listening to people on this, I don't have a view one way or the other, but I was just thinking as an academic that in a way, this is the debate between what we would call contractarianism, which is, I suppose, the US corporate law perspective, which says let companies decide what they want, versus maybe what we might see more maybe in the UK or Europe, where company law is more regulatory and facilitatory. It might be less likely to say let companies decide what they would like. But that is essentially the debate we're having between how much freedom of contract do we give companies? Do we say it's up to each company to decide if they like online only, a la Jimmy Choo, or do we actually say, no, we don't think it's good, we're going to say this is bad for shareholders? I thought it was interesting to hear from Hans Kristoff about those 6 to 7 hour meetings in Germany. And again, I was staring into the wording then of the Shareholders' Rights Directive, and I see that is allowed because we look at the wording, it doesn't actually prevent adding additional restrictions, such as that each question must be answered. Rather, it says member states may, if they wish, use confidentiality or orderly conduct not to answer. On that, I think rather than having a 6 hour meeting, I do think maybe that all questions should have to be answered on the website, that we should look for transparency. And I know Roger, I think, mentioned useful ideas about moderators, independent moderators, and that's something I think that might be a useful one too, to ensure that we're not getting the runaround and that tough questions are not being filtered out. And again, maybe that goes to what is the interest of the company, subjectively decided by the directors. So, those are just some thoughts. Just one other, I suppose, final thought was, we're going to be witnessing electronic single, I can't remember what let me just see, electronic format reporting for financial reporting coming in next year, which will mean that annual, financial reporting will be not just in human readable form, but machine readable form. And this is exciting because it will allow a lot more, I suppose, analytics it will be kind of tagged with this XBRL language. And I think we're going to witness that as well. I'd say it's going to happen with ESG data, that in the future, the type of questions that are being posed may be a lot more probing based on being able to sort of deep dive using AI analytics. And, I do think, technology will shift the whole way things are done. So it's kind of not a matter of if, it's more of a question of when we see all this. I suppose it's up to Kristoff and others to discover how we're going to do the DLT side. So those are just some thoughts I have at this stage. I think for the most part, EU law permits a fair amount, but perhaps it seems a little dated now. We have to be careful about being technology neutral. But I do think if we're going to have online, I think we should have video at least, so that if we're not eyeballing them in the room, we can at least eyeball them on Zoom. Thank you.
Right, thank you very much, Deirdre, for your thoughts, and some of them very, very interesting. I think George wondered about whether or not chat can be used constructively, actually, among shareholders, as opposed to what you suggested about collusion. Shall I invite George to make that comment?
Yeah, and Deirdre, it was great comments, and I cheekily did this via chat on purpose, but to be a sort of a muckraker. No, but I think the point is collective engagement is legitimate and can and should be encouraged within proper boundaries and guidelines as defined by the Takeover Code and what have you. So if I'm not sure I said that to be cheeky, but I think I do have an honest point. Is what if the nature of a discussion in a meeting of this nature could rise issues that hadn't possibly cropped up before, so that it might make sense for shareholders within proper boundaries to basically exchange views. I'm not sure I see why that should, I'm probably missing something huge legally. I mean, I'm not a lawyer, but I'm not sure what the problem is.
Right, shall I have Deirdre respond first?
Yeah, I sort of don't see it as a problem. Maybe I'm just aware of the cynical view about filtering out possible kind of tensions in the room, or ganging up or etc. that wouldn't happen normally by virtue of being able to sort of manage very skillfully the questions and which ones were deemed to be similar to other ones and not answered, etc. if necessary. So yeah, it's just that all hell might break loose, I suppose.
Maybe all hell should break loose sometimes.
True.
Right, Hans Kristoff, would you like to give us your comment?
Yeah, just to add, I mean, in Germany, you can also look at 8 to 10 hours. So the 6 hours was quite a short one. The Deutsche Bank is an example where they actually had this year a TV moderator reading all the questions, and that probably added a little bit to the time. But my understanding, there are probably German lawyers in the audience, but you need to answer all of the questions before the voting takes place in the German system, because otherwise you can claim you didn't have the information and the vote was invalid for some reason. So that's part of the reasons why it's very difficult in the German system for the chair to say no, we finished and no more questions. And yeah, they need to be answered before the voting, which I think is a challenge, and they probably need to look at their 50-plus-year-old corporate law in Germany at some point.
Right. Actually, I was actually wondering whether Deirdre wanted to address this, which is, even though EU directives want to be technology neutral, I mean, we can't really be completely technology neutral. I mean, all laws in the end make some assumptions about what formats we have, what methodologies we would use. And I'm wondering whether or not this pandemic may highlight to us the need to come up with either even broader principles for meetings or some provision on technology and to harmonize it across the EU. Because for example, I mean, the German practice of having 8-hour Zoom meetings might not be welcomed in other jurisdictions. And would it be beneficial for some form of harmonization? What are your views?
I think maybe I would go with Vanessa's idea of best practice guidelines that can be easily altered as needs be. I suppose when I said technology neutral, I meant that we wouldn't look to prefer one technology over another. The danger when you're dealing with new technologies is if you try to regulate, things evolve quickly, and you know, it may be that the platforms do as well. I mean, we're mentioning Zoom now, but Zoom might be yesterday's news soon enough, hopefully. But, you know, I think it's just to be careful if we're writing rules. And that's why I think I would always prefer guidelines that, you know, something like the Chartered Governance Institute or something like that, that, you know, that you can actually have that can be responsive to change in an area which does change quickly, as opposed to hardwiring in rules. And also legislation, etc., is remarkably intransigent and difficult to change as well at a pace. So yeah, that would be what I would say to that.
Right, thank you very much. I don't appear to have received any audience questions. I think it could be that the audience has stuck with us for almost 2 hours, and they have. I hope they have benefited from our discussion, but they might also be tired after a 2 hour Zoom meeting. I don't know how many hours you have come, you know, from, but I'm just wondering if anyone would like to have a last word on this particular topic, on going forward, what you might think would be the key challenges, the key changes for shareholders or corporations before we close. Anyone? All right, George.
Oh, sure. I think Vanessa raised her hand first, so I'll give the floor to.
Right. Okay. Sorry. Yes, I don't have a full gallery view.
Oh, okay. Yeah.
Okay, thanks, George. I was just going to say I really agree with Deirdre that being technology neutral is really important, particularly if we're going to try and do things at an EU level, because it takes such a long time to get agreement and technology moves so fast. And I also think that guidelines for the more detailed stuff is a better way forward, because it's more flexible and it can respond to the changes that we're seeing in stewardship and engagement. And I think you're entirely right, Deirdre, about how standardization of reporting, whether that's ESG or other things, is going to mean that things will become possible that haven't been in the past. One small point is this idea of having an independent moderator on the questions. I fear that could be quite an expensive solution. So maybe if we're going to go down some sort of route to deal with this question about how do we know what questions shareholders are asking, how do we know whether the company is arbitrating fairly between the questions that are being asked and what it's dealing with, we could maybe give companies a choice of either they make all the questions freely available to shareholders so they can make their own judgments, or if for some reason they don't want to do that, then they have to have an independent person to be the moderator on that.
Right, shall I invite George to give your comment?
Yeah, just very, I think it's been fascinating, and thank you for organizing this. I think standardization is the direction of travel that we need to try to embark upon. It's going to be bumpy in different jurisdictions. But I guess my final message is I think that the future, you know, is if we crack the virus and what have you, the future will still be different from the past. And I think we need to embrace the future. There's the Russians say trust but verify. You know, maybe we could modify that concept to say, you know, embrace the technology, but protect shareholder rights. And that's why I think is all this part of what I think we try to contribute through our reports, and what I think the discussion will evolve to is as these standards and norms begin, at least as principles, and then maybe over time, if they can be hardwired, if there's evidence, but at least we need to start to factor in a multi-equilibrium setting where the company has its needs, shareholders have their needs, stakeholders have their needs. I think we need to ensure that as we change, that our basic rights are not compromised. And so this could be potentially a better world, you know, a better solution than the ones we've been having in the past.
Right, thank you very much, George. In the meantime, we have had two questions come in from the audience. And I think these are posed to the entire panel. I mean, the first question I have on hand is very interesting, which is, would it be beneficial to have a central regulatory body monitor virtual AGMs? I think my gut feel is that we really shouldn't try to chunk it up all the time, that something which can be privately managed between a group of kind of arm's length constituents should be, sent up to be monitored by a central regulatory body. But I would love to hear views from the panel if you would wish to address this. Anyone? Roger, please.
Yes, I mean, I'd agree with you, Iris, with respect to that, but just with regard to the point that having some kind of independent person, that could be too expensive. I mean, we should remember that shareholders do ultimately employ a certain group of people to investigate and engage with the company on their behalf, who happen to be also really very expensive. That is, of course, the external auditors. So in a way, this kind of would be analogous, but with respect to shareholder engagement at AGMs.
Right, okay, thank you. And I also thought that one of the implications would be that stewardship would have to be something that's regulated or monitored. And I think the question remains open as to whether or not, that is desirable. And the policymakers in the UK have certainly taken the view that it's best to play a facilitative role up to this point. Right, the second comment I have is about fairness between physical attendees and virtual attendees at AGMs that go hybrid. So if we have that future, would it be necessarily fair between both groups of attendees, and would it necessarily prejudice the virtual attendees? Just wondering if George in particular, might be interested in taking this question.
Well, I think you're going to have this. I mean, people who submit proxies prior to the vote, don't sit in the meeting. I think this problem is not going to be avoided in any circumstances completely. I think we just need to deal with the world that we have and to make this work as effectively as possible. And I would hope that the possibilities of technology and virtual meetings can, make it as close to a real experience as possible. But again, the point about informal communications and what have you, you can't really replicate that. And so I think that there's always going to be a bit of a difference. And I think the key is to, make it as small as possible.
Right, and Hans Kristoff, you wanted to add something?
It's already not equal. I mean, as an institutional investor, you always get, I think, some preferential treatment at AGMs, particular where you have sometimes in some countries the right to speak for 10 minutes, then the chair uses discretion to pick the institutions normally first, and I think that's just reality, but just making sure that these unequal treatment, that this doesn't get worse because of the hybrid meetings, I think is a key. But the fiction of equal treatment of shareholders, I think we should all move on. That this is just not realistic.
Right. Thank you. And I think this probably dates back to the first stewardship code and recognition that institutions have been basically playing a more dominant role. And over the last 10 years, we have basically just emphasized more and more the importance of institutional shareholder engagement. Right. Thank you all, my panelists and the audience for staying with us and exploring this very interesting topic. I think we have raised many interesting questions, unanswered questions, and experimental practices that we'll have to go on trying out, as this pandemic lasts. And as suggested, the next AGM season will likely be facing the same issues. So we'll be keeping watch on the changing practices, and hopefully many of us will come back again and have formal or informal conversations on this evolving and very, very interesting topic. So I'd like to thank my panelists once again, and my audience as well. Normally I would have been able to invite you to a drinks reception after this, but hopefully we can resume that practice in Well, I'm looking at 6 to 12 months. I'm hoping, and the center would very much love to have you back with us physically in one event or another. So thank you very much again for being here today.
Thank you,
Right,
Iris.
so let me call the proceedings to a close. Thank you.